Hello, kids. Welcome to the Fearless Floyd Show. I'm your host, as always, Fearless Floyd. If you need to reach me, TheFearlessFloydShow at yahoo.com. At yahoo.com. Subscribe to my channel. Hit that like button if you like my video. Hit that notification bell wherever it is so you can get notified when I put out a new video. And share the video with many people as you like. It is copyrighted, but is what it is. I allow it to be shared. Today's topic, we're going to talk about my own personal writ of certiorari to the Supreme Court of the United States of America. And as any of you who know me, have watched my videos, you know I have a little bit of a legal background. Not much, just a little bit. And if you read the About Me section, you'll see that been around the block several times. Mouse problems over here. I see what happened. Okay. That's some debris on the button. I'm still not going. What's going on here? Oh, my mouse died. Anyway, let me finish with the video. Writ of certiorari to the United States Supreme Court. So I wanted to show you guys. Okay, I'm going to go ahead and brag a little bit. You know, show you what I'm capable of when I really sit down and focus and put my mind to it. Here we go. All right. Jack this up for you guys. All right. As you see, of course, now it wants to work. Stupid mouse. Anyway, uh, this is my copy, and as you see, it's 73 pages, and this is the cover page. This would be the number assigned by the clerk of the Supreme Court of the United States, which at the time was William K. Souter, Floyd P. Tarvin IV, petitioner, pro se, versus the state of Texas, respondent. On petition, a writ for certiorari to the Court of Criminal Appeals at Austin, Texas. Petition for writ of certiorari, Floyd P. Tarvin IV, petition pro se, TDCJ number, WIN unit, Huntsville, Texas, 77349. Video teleconference available, blah, blah, blah. That's the unit phone number. Okay. I don't know what this black stripe is. I think it was in the scanner when I scanned all this. This was done with a typewriter. And in 14 years, well, actually 12 years that I did litigate, I went through 32 typewriters. Yeah, absolutely. Just a little over 2 a year. About every 6 months, I'd wear one out. So these are my questions for review to the court. Question 1. Has the state of Texas failed to establish felony driving while intoxicated jurisdiction by applying Texas Penal Code Section 4909B2 and not applying Section 4909E1 and 2 to indict, prove guilt beyond a reasonable doubt, convict and sentence him beyond the statutory allowed maximum sentence for all evidence presented in violation of the 5th, 6th, 14th Amendments to the United States Constitution? Question 2. Has petitioner's due process rights been violated in his felony driving while intoxicated offense for wanted jurisdiction due to the state of Texas applying Texas Penal Code, blah, 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 basically states the same thing. And question 3. Has petitioner's right to trial by jury been violated in his felony DWI offense for wanted jurisdiction due to the state? Same thing. Okay. Question 4. Is his conviction void for want of jurisdiction? Same thing. 5. Is judgment void? Okay. Conviction, judgment for want of jurisdiction. Because jurisdiction of the court can be challenged at any time, at any stage of the proceedings. So even today, I can go back and file for want of jurisdiction, which I'm on my way. Has the state of Texas failed to establish felony driving while intoxicated jurisdiction, and then fail again to establish felony driving while intoxicated of personal and subject matter jurisdiction, terminating the proceedings, violating his due process rights, right to trial by jury, and voiding both his judgment, sentence, and conviction by the 351st Judicial District Judge Mark Kent Ellis himself, amending petitioner's indictment, violating his 5th, 6th, 14th Amendments to the United States Constitution. Because under the Texas Code of Criminal Procedure, that thing, it's the prosecutor's job to interlineate and initial and date any alteration or amendments to an indictment in the state of Texas, not the judge. When the judge does it, guess what the judge is acting as? He changed hats. He became the prosecutor. Is he supposed to be impartial? Not so. List of parties. Here I am, the petitioner pro se. State of Texas respondent. Table of contents. Here's my questions presented. List of parties, table of contents, index to appendices, tables of authorities, which are Court of Appeals in Texas, Court of Criminal Appeals, Texas, District Court of Appeals, United States, Circuit Court of Appeals, United States, Supreme Court, United States, codes, criminal codes of Texas, penal codes of Texas, criminal codes of the United States, constitutional articles and amendments, actually articles and sections of the Texas Constitution, and amendments and articles of the United States Constitution, additional legal sources and publications, opinions of the lower court, jurisdiction, constitution, and statutory provisions involved, statement of the case, question 1, and then it's broken down. You see, I had to handwrite these pages in there. Is what it is. That's a lot easier. You can see a lot of this stuff I had to go back and clean up with a pen for typographical errors. You can see how all this is numbered. So if you want to see reason for granting right there, that's between page 29 and 31. So we can scroll down and you're going to find that on those pages. Okay. We'll go down here, index of appendices, and these are all the evidentiary documents that I submitted. Order granting extension of time to file a motion for rehearing en banc of Court of Criminal Appeals at Austin. Okay. Yeah, I've done some crazy stuff. Okay. Special motion for rehearing en banc with amended petition for discretionary review in the Court of Criminal Appeals at Austin, Texas. Okay. Let me just back up and read some of these. Memorandum opinion of the First Judicial District Court of Appeals at Houston, which is, we have the 1st and the 14th here. Judgment of the First Judicial Court of Appeals. Order granting extension of time to file motion for rehearing of the First Judicial Court of Appeals at Houston. Order overruling, order refusing, discretionary PDR is what we call it for short. And basically this is all my trial stuff, and then I actually printed out Texas Code of Criminal Procedures. I'm going by a little fast, but you got to put this shit right right in these people's faces. Now, you see right here, indictment of Robert L. Edwards. Okay. Um, because I was a DWI expert and still am, I would get people, anybody who had DWI, they came to see me. So I got these other indictments, and I was able to use those as an example that in all felony indictments in the state of Texas from September 1st, 1994 to August 31st, 2001, the state failed to allege the commission date of the intervening DWI to create a felony DWI. So basically, everybody who was convicted and sent to prison or probation for a felony DWI between that date is actually a misdemeanor, not a felony. So Ricky Lee Jenkins, I forgot all about Ricky Lee. This guy right here, Edwards, man, he got 13 DWIs. You see, I did both of these guys. Did the legal work for them, so I had access to them. And Eugene Bollinger, here's another alcoholic. If I remember correctly, this guy died in prison. So what I'm doing is showing these as examples of hey, one right after another. Because what they do is they have these books right here, and these are published by, you can see that, the Texas District and County Attorneys Association. So I would always get these books because, now I got their playbook. But their playbook, which gave them a boilerplate template to write the charge, which is the complaint, and the indictments, and the charge to the jury, all incorrect. So fundamentally, right off the bone, they they were in error. Now they amended the law in between September 1st, 2003 to August 31st, 2005. And then in September 1st, 2005, they did away with all this little hinky jinky, look forward, look backward, look, all that crap. So anyway, this is my table of authorities. And this is Adamson versus Blackmar, 546 Southwest 2nd Series, page 698. And it was out of the 3rd District Court of Appeals in Texas from 1977. And you can find this citing in this writ of certiorari at page 31. This case, it's cited on page 26. This case, boom, 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 as you can see. This is right here, Getz versus State. That's what the whole thing hinges on, as well as some Supreme Court cases that we'll get to here in a minute. We've got to wade through all these courts of appeals. Yeah, still in the courts of appeals. There we go. Now we'll get to the Court of Criminal Appeals. Okay. Appendices versus State, 866 Southwest 2nd Series, page 210 from 1993 on page 35. And this is only 73 pages. My writ of habeas corpus, my state writ of habeas corpus under Code of Criminal Procedure 11.07. The application was 50 pages, and the brief was 350 pages put together just like this. It took me 3 months to type it up. Absolutely. Circuit Court of Appeals, United States. This is the First Circuit Court of Appeals, which is New Orleans. It would be the Northern District of Texas, U.S. District Court. Supreme Court of the United States. Alamanderas Torres, that's a key case. Apprendi versus New Jersey, that's a key case. Arizona versus Fulamante, that's a key case. So I got Dred Scott in here. Way back. Duncan versus Louisiana. There's some old, real precedent cases. Ah, this man, I've been looking for this case. Ferretta versus California. When you go into court and you tell them you don't want an attorney, and the judge is required by law to give you an admonishment regarding self-representation, this is the case right here, Ferretta versus California, that dictates that they have to do that. Okay, that's what it's all about. Our Henry Winship, that one's a key case. Jones versus United States, that's a key case. You can see many sightings, and I had to put it on different pages. You know, the case is Marbury versus Madison. Huh, where have you heard that before? McMillan versus Pennsylvania, that's a key case. And what the Ring versus Arizona? Kind of familiar, reminds me of Shad versus Arizona. Um, Booker. Nah, Booker doesn't play anything into this, does it? Look at that. Absolutely. And what those cases are about are elements of the offense that they must be proven beyond a reasonable doubt, clear and concise. And if all the elements of the offense aren't alleged and proven beyond a reasonable doubt, they can't convict you. Okay, these are the Texas criminal codes of procedure, penal codes. Of course, 4909, that's DWI enhancement. That's just a basic DWI, 4904. And of course, you can see I go back in these different legislators when they enacted these, and these are all the amendments that they did to them. Of course, and this is what I fall under. And these are Title 28 USCA codes, Texas Constitution, Articles and Sections, United States Constitution, Articles and Amendments. These are supplemental and other legal resources. So, um, so if you wanted to cite this book, or you wanted to cite that book, this is the section. And of course, you see, here's Blackstone commentaries, Black's Law Dictionary, 7th edition, 8th edition, American Heritage Dictionary of the English Language, 1982. That's actually the book right there. And still got my tag on it. And you see these rings? I bet none of y'all know what those rings are. They're on both sides. Industrial cans that they have like in hospitals and restaurants, big ones. Well, back in the day when you could smoke in prison, those were butt cans and they were everywhere. So you set your book on that butt can and you had a place to sit. And that's what those rings are. And this is a very old book from 1982. And it's a survivor. And it made it out. And you can see underneath there all these other names, all these other people who own this book. So, piece of history. So anyway, let's continue. And you can see, you can see it, obviously. I didn't read a fucking thing when I was in prison. Huh? Nothing. Never read a book. I don't know anything about the law. I'm just stupid. Okay. Lower court opinions. Of course, they won't publish anything. They just flat out would not let me win. Jurisdiction. Constitutional statutory provisions. Statement of the case. Petitioner was arrested in Harris County, Texas for the offense of driving while intoxicated by police on July 10th, 2001. Grand jury indicted him for a third-degree felony DWI by the use of two prior DWIs from 1987 and 1994 under the Texas Penal Code, Chapter 49. The indictment also alleged two prior felonies and enhanced the punishment to a level 25 to 90 years or life imprisonment. Petitioner's three-day trial concluded May 22, 2002, with the jury finding him guilty of DWI and that he had been twice previously convicted of DWIs as presented in his, quote, stipulation of evidence, unquote. Punishment was elected to be by the trial court, which sentenced the petitioner to a 60-year term of confinement in the Texas Department of Criminal Justice Correctional Institution Division on August 15, 2002. Petitioner filed a timely notice of appeal to the First Judicial District Court of Appeals, Houston, Texas, which affirmed his conviction on February 19, 2003. This same court granted extension of time on March, and I wrote that in later, 2004, and overruled a rehearing on April 29, 2004. Petitioner's appointed appellate counsel filed a timely motion for petition for discretionary review that was refused on September 15, 2004. Petitioner terminated his appellate counsel on August 7, 2004. See Appendix 2, because by then I was self-educated enough to handle my own affairs in the legal realm, and I fired that punk. Tom Moran. Don't hire Tom Moran, okay? Of Schneider and McKinney. No. POS. He filed his timely extension of time that was granted on September 30th, 2004. He then filed a timely special motion for rehearing en banc with an amended petition for discretionary review that added, by amendment, the jurisdictional questions raised in this petition for writ of certiorari. The Court of Criminal Appeals at Austin, leaving it blank for either denied, dismissed, or whatever they want to do. Petitioner's special motion for rehearing en banc with an amended PDR on such date, 2005. Thusly, he files this timely petition for writ of certiorari and presents this most high and honorable court with 6 questions for review. Reasons for granting the petition. Tarvin, hereinafter the petitioner, submits a petition for reasons of such great import that the questions presented hereon are so fundamental and are the root of all jurisprudence in this world, so basic and pure that this court allow them to be presented in any court at any time, at any stage of the proceeding. Just like I told you earlier. Quote, the Supreme Court must decide a question of jurisdiction arising on the record, though the court's jurisdiction is not. McKinney versus Carroll, 37, United States, 66, 1838. I didn't reach back very far, did I? Where court does not have jurisdiction of subject matter of proceeding is quorum non judice and void. Okay. Petitioner added by amendment in his PDR questions that the state of Texas had failed to allege and prove subject matter jurisdiction of a third-degree felony or, quote, lack of jurisdiction may be raised in any stage of the proceedings, unquote. And, quote, defects may be recognized by a court at any time. unquote. I'm going to leave out the quotes because petitioner now presents this petition for this court to decide these jurisdictional questions that affects every person arrested in the U.S. He brings forth the fact that the state of Texas is applying Texas Penal Code Section 4904 or 4909 B2 and not applying Section 4909E 1 and 2 as required by the 73rd Texas Legislature's intent. Thus, the state's burden of proof is lessened. Felony jurisdiction is not established. Due process is violated. His right to trial by jury is violated. His conviction is thusly void, and the judgment is void as well. The fact the state has failed to allege and prove the commission date of the petitioner's intervening prior DWI conviction that occurred within the 10-year rule of limitations as required by Section 4909E 1 and 2, they have not established subject matter jurisdiction of a third-degree felony DWI. The petitioner also raised the question that if the state is granted a right to amend the petitioner's indictment and allow the trial court itself to amend the indictment and never resubmits a legally valid indictment, that the state failed to have any personal and subject matter jurisdiction over the petitioner. The petitioner has abandoned the two errors brought forth by his appointed appellate counsel, Tom Moran, on appeal, as he feels that the errors now brought forth are more important to Texas jurisprudence that affects all felony DWI offenders, as I was alluding to earlier. Petitioner will show that the state of Texas has failed to allege and prove an essential fact that triggers a simple misdemeanor DWI under Section 4904, the maximum sentence of 180 days in Harris County Jail, to a third-degree felony DWI under 4909 1 and 2 and E 1 and 2, that the sentence is 2 to 10 years confinement in TDCJ, and in this petitioner's case, 25 to 99 years or life, which he was sentenced to 59 and 1/2 years beyond the statutory allowed maximum sentence, as alleged in the indictment and proved beyond a reasonable doubt. Statistics taken from the Texas Department of Public Safety conclude that there have been an estimated 78,000 felony DWI convictions from 1994 to 2004. And using statistics from the National Highway Transportation Safety Administration, the numbers could be as high as 109,000. See Appendix NN, capital NN. The petitioner also presents exhibits located in the appendix of other felony DWI offenders that also present the exact jurisdictional defects as stated herein. This defect is should be not an isolated occurrence. It's pandemic in Texas. It should be epidemic, actually, because pan would be worldwide. My bad. I made a mistake. And we're only on page 3. We just got what, 50 more, 48 more, something like that. And then this is the question. Has the state failed to establish felony DWI? Which you've already heard. Okay. Reason for granting the writ in question 1. And basically, Texas statute. A standard of review. Congress' basic statutory goal. A system that diminishes sentencing disparity of real conduct that underlies crimes of conviction. That's Booker. We ought to presume, whenever possible, that those charged with writing and implementing legislation will and can apply the statute consistently with constitutional command. That's Booker again. Breyer was, I think, wrote that. A statute that does not explicitly set forth a standard of review may nonetheless do so implicitly. Adopting the standard of review where neither a clear statutory perception nor a historical tradition existed based on the statutory text and structure and on impractical considerations. We infer appropriate review standards from related statutory language, the structure of the statute, and the sound administration of justice. That's Booker again. Booker was a very important case. Okay, and I can go on and on and on. Y'all getting it? Let's scroll up here to let's stop page 40. 40. Petitioner's pleading ought to be so clear and definite that the date of his prior DWI was alleged to have been committed should have been stated within. The burden of proof is always on the state to show that the prior DWI was committed within the statute of limitations or the 10-year rule, regardless of the date alleged. Petitioner's failure to object to the limitation defect on the face of his indictment did not relieve the state of its burden at his trial, proving that the 1994 prior DWI occurred within the 10-year rule. The prior DWI commission date must not be so remote that the date of the offense is barred by limitation. If petitioner's indictment shows on its face that the prior 1994 DWI is potentially barred by statute of limitations 10-year rule, the commission date tolling the 10-year rule must be alleged. The state has the burden to plead and prove the commission date of the 1994 prior DWI, which would tell the 10-year rule and vest the court with felony jurisdiction. If the state does not, the indictment is fundamentally defective. The commission date must be alleged in plain and intelligible words that petitioner did all things which would constitute a felony DWI. Petitioner's indictment, which tracks the language of Texas Penal Code sections 4904 and 1240 and 1243, which is the yeah, that's right, that's penal codes. Is legally sufficient for a Class B misdemeanor with enhanced penalties for a habitual misdemeanor offender, and petitioner's indictment merely tracking Texas Penal Code Section 4909B2 is insufficient if it fails to also track 4909E1 and 2, the commission date of a prior DWI, an ultimate fact of life. The court decided that the date of the commission of the two prior offenses as an element of the offense is an evidentiary matter that the state must prove at trial, and found that the evidence failed to show the dates when the offenses were committed. The prior DWI convictions are not enhancements to be used at the punishment phase, but are part of the proof offered by the state to prove for felony DWI. And I can just go on and on and on and on and on. Okay, and then there's Getz. I told you that's pretty much the holding case. And then, of course, there's Alameda Torres, Shad, Ring, Blakely versus Washington, Booker, more Booker. Okay, there's Henry Winship, Shad again. Okay, those are like big major Supreme Court cases, precedent, all talking about the elements of the offense. And I can just go on and on and on. So basically, in a nutshell, folks, what they did is they failed to allege my intervening DWI commission date. And how they did, the Texas Penal Code was overhauled in 1993, predominantly by Houston State Senator John Whitmire, and enacted in September 1st, 1994. And that's when they moved the DWI from uh, was it 8711, section 8711 of the Texas Transportation Code, and moved it to the Texas Penal Code. So between September 1st, 1994 to August 31st, 2001, it stayed the same. They amended it the next legislative session, which I showed y'all above that I alleged, and then they amended it again. And the problem is that between 94 and 2001, you had to go back 10 years. If you committed one within 10 years of looking back, they had to allege that it was committed and that you were twice previously convicted of a DWI. So they would go back, and if there was a commission date within 10 years, they could use that conviction, and then they could go back as far as they wanted and grab another conviction. Didn't matter if it happened in 1932. They go back there and grab that. Now they got two convictions, and they can use this intervening conviction because it was committed within the 10-year rule of the primary conviction, which or primary offense, because you hadn't been convicted yet, as I alleged above, July 10th, 2001. Correct? Okay. In September 1st, 2003, they amended that. Or no, I'm sorry, 2001, they amended it because there was a little confusion about how it should be alleged in these indictments and how it should be addressed in court and then how it would be addressed on appeal. So they didn't know if they were looking forward, backward. They needed clarity. So it eventually got to the Texas Court of Criminal Appeals. Getz, okay, Getz versus Texas, and that is the predominantly holding case. However, in 2003, they changed it and they went back to the first DWI and they looked forward 10 years. So if you committed one within 10 years of your first DWI, they could go get your other one because this was all the Mothers Against Drunk Driving. They were out there. They were pressuring legislators in Texas. Hey, there's too many people getting killed by DWI, and I agree with that. I'm not fucked up a bit about going to prison, doing my time. I used it wisely. Obviously, you can see I educated myself. Everything I know, I am self-taught because I dropped out of school mentally in fourth grade. So everything that you see and I do, self-taught. Um, Go Fearless. Uh, so anyway, bringing that up. So I showed you the two chains. Okay, so they were finding it difficult in the courts of appeals and in the trial courts, and to decipher what the hell the legislature was doing. They were getting all this pressure. They just, this is too confusing. Can we make it simpler? So September 1st, 2005, they changed Section 4909, and they eliminated Section E. And all they did was made it real simple. If you've been twice previously convicted of a misdemeanor and or felony DWI, just convicted, that's a wrap. That's a third degree felony. Okay. So they simplified it. And I get it. And it makes sense. And, it should have been like that all along, but somebody was trying to get clever somewhere in the legislature. They slipped that in. And hey, guess what? 6 months is all I can do. Done it many times over. Somebody owes me some fucking money. Now, we're getting down like that. So I want to show you guys who I am and why I am and what I'm about and what I'm capable of doing. And I'm giving you my Bonafides. So when I sit up here and I talk to you and tell you guys stuff, I'm not blowing smoke out your ass. Fearless Floyd's been there, done it. I've done the research. I've done the homework. I've written these writs. I've written these petitions and actual innocence claims and fucking read forensic reports and autopsies and freaking you name it, man. I've done it. Okay. I know how to write. I know how to put together a legal vehicle to file in any court anywhere in the world. Slip opinion. Anybody know what a slip opinion is? You watch my previous video, you know that's private, not public. Mm-hmm. Friendly. Okay. Because this is what they do. They say, oh, that's a sentencing factor. No, it's an elemental fact. Okay. It's not a sentencing factor. It's from the late Justice Stevens. He's passed away now. Okay. Question 3, and I can just keep pounding this for you guys. But here it is. It's all in black and white. So when I walk the walk and I talk the talk, you know, I think this is like this is the only surviving legal document that I have of everything that I've done, and I guarantee you, if you took all of it, it'd probably be as high as that right there. Absolutely, stacked like that. Hmm. Yeah, I was a machine. That's all I did, legal work. If I wasn't in my cell typing, writing, drafting some of these vehicles, I was in the law library reading, studying. If I could go 8 hours a day, that's where I was, 8 hours a day. Clockwork. Everybody knew where to find me. Yeah, he's not in a cell, he's in the law library. I try to add a little humor in here. Judgment Day, judging the judgment. This gets when you're reading petitions and briefs and rebuttals and traverses and motions. After a while, you're just like you're reading all this stuff, and it's just like it's real monotonous. So I always like to throw in, just little nuggets here and there to, maybe change the tone to from monotony to, oh yeah, Judgment Day, okay, yeah, he's kind of cute. Because the judges don't read this, the justices don't read these. They have clerks that do all this. Okay, and here's see, Judge Mark Kid Ellis, and he initialed it MKE. Really? Really, Mark? You put your mark on my indictment? Voided it? Thanks, dude. Appreciate you. And then he slammed me to 60 years. Yeah. Tight. 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 Fearless Floyd ain't done, bro. I'm just getting started. I just need more time. So, if I disappear for a minute, a hot minute, you know what's up. I'm being focused on what I need to do. As you can tell, I know what I can do. It's just me doing what I need to do. And there's block burner. Yeah. Are you bored yet? Yeah, here we go. My judicial notice, putting them on notice. Petitioner's original copy of this writ and appendix are currently lost in the U.S. postal system. A trace was initiated on May 12, 2005. Petitioner is trying to procure replacement documents for the appendix and will forward all parties a copy when compiled, hopefully in 2 weeks. Jesus Christ, I wrote this in 2005? You ought to see my shit 7 years later. This is uh this is 3 years of studying law. Imagine another 7. Yeah. Oh, I wrote some just, nuclear bombs, baby. This is good for everybody right here. You should all, if you're going into court, you all should cite this section right here. Petitioner proceeding as a use pro per, because you're coming in proper, don't use pro se. A pro per litigant must be ensured meaningful access to the courts and is allowed some degree of flexibility in pleading his action, and should be construed liberally and held to a less stringent standard than formal pleadings drafted by lawyers. If court can reasonably read pleadings to state valid claim on which litigation could prevail, it should do so despite failure to cite proper legal authorities, confusion of legal theories, poor syntax and sentence construction, or litigants' unfamiliarity with pleading requirements. Y'all like that? Yeah. Service. William K. Sutter, clerk. Appendix, table appendices, which is a repeat of what's up front. Texas Penal Code. Rehabilitation. I got that right. Yeah, they got all this right. Such punishment as may be necessary to prevent likely reoccurrence of criminal behavior. See, it's all about behavior, folks. You're not going through a substance abuse treatment program, you're going through a behavioral modification program. Change your behaviors, be able to recognize that's a criminal behavior or that's a bad behavior. And the worst thing right here, what people can do is addicts is lie to themselves. And it doesn't matter what kind of addiction you have. You're lying to yourself. And then if you lie to yourself, you're lying to everybody, no matter what comes out of your mouth. And Constitution of the United States. I had to type all this crap in Black's Law Dictionary, so I'll tell them what I feel that the definition of these specific words. You see, I address facts because that's what we're talking about, a material fact, an elemental fact. And these are the arrests and convictions to show you felony DWI convictions. And this is from the, remember I quoted this earlier from the National Highway Transportation Safety Administration. Those people. I got the books, folks. I ordered them. I read them. Read all these. I did my homework. I told you guys that. So, what does all this mean, Fearless Floyd? Damn, you just took us through a whole freaking book, 73 pages. I'm bored. Give us some excitement. Well, what this means is that everybody that was convicted of felony DWI in the state of Texas between September 1st, 1994 to September 1st, 2005, or August 31st, 2005, that's the legislative window right there, not been properly charged, indicted, um, and convicted of a third degree felony pursuant to Section 4909E of the Texas Penal Code. That's what it's all about. So there you go. We have a little historical aspect of my capabilities. What? Yeah, you should go put on some makeup. That's a wannabe movie star. It never was, never will be. Jealousy's a fickle bitch, isn't she? Anyway, so you have a little bit about me, and you understand who I am, where I come from, why I am the way I am today, why I am able to reach in my pocket, not only pull out real silver, be able to hold that up. That's my 19-year chip. I don't know where my other dime went. I'll have to go find it. And that's what made me who I am today. So when I tell you that I've been there and I've done it, I've got the scars, I've got the record, got everything to prove everything I've ever done. I don't hide behind anything. I'm not here to buffalo you. I'm not here to blow smoke up your ass. I'm not here to tell you what you want to hear. That's just not who I am. Like the video, subscribe to my channel, share the video, hit that notification bell. You can always reach me at TheFearlessFloydShow.yahoo.com. Leave a comment below and tell me what you think. Hopefully, I educated you and showed you a little bit more about my skill level, my expertise. Because I walk the walk, I talk the talk, and I know my shit. And with that, thank you for watching. And again, by the grace of my heart, I thank you all for watching, subscribing, liking, sharing, all that, man. I'm just so grateful that I have as many people that want to watch my videos as I do. So, y'all have an awesome 2022, guys. Thank you.